Welcome to the deep dive. This is where we wrestle with really dense source material, could be legal texts, philosophy, deep history, and try to make sense of it together.
That's right. And today we're going deep, really deep, into Roman society.
We're looking at something absolutely fundamental, maybe one of the least understood parts of Roman life for us today. The incredible power held by one person, the paterfamilias, the senior male head of the household.
Exactly. And if you really want to get why Rome worked or, how it held together for so long, you have to understand this domestic structure. It's rigid.
Our sources today are pretty heavy hitters, aren't they?
Oh, yeah. We've got the big Roman jurists, Gaius, Ulpian, plus insights from thinkers like Cicero. And honestly, the picture they paint, it's of an authority that's just, well, it's hard for us to wrap our heads around today.
Yeah, we're not talking about like strict dad vibes here. This is codified legal status, near absolute power.
It's called patria potestas, literally fatherly power.
Yeah.
But that translation barely scratches the surface.
It went so much further than anything we'd call parental authority now.
So much further. The Romans themselves saw it as foundational, like the cornerstone of the state itself.
Okay, so our mission today, what are we trying to achieve?
Simple but big. We need to unpack the whole legal and social framework behind this power, figure out who was actually subject to it, who was in potestate in the legal jargon.
And then explore the limits, or maybe the lack of limit.
Precisely. The control over family, property, legal status, even, the very personhood of dependence. It gets pretty intense.
So prepare yourself. This is about legally defined absolute obedience.
Right. So when you approach Roman society, you have to kind of reset your thinking. We tend to start with the individual rights.
But Roman law starts somewhere else entirely.
It starts with the familia, and we need to be clear what that means.
It's not just family in our sense, is it? Not just blood relatives.
No, not at all. The sources are really clear on this. The familia was fundamentally the house itself. Think of it less as a group of people, more as an entity, an economic unit, a legal unit, even a religious one.
Okay, the house itself. So that includes...
Includes everyone living under that roof, subject to that head of household. So yes, free citizens, sons, daughters, grandchildren,
Yeah.
but also slaves. Everyone designated as servile. And crucially, it also included all the property.
Yeah.
The land, the goods, the resources, everything.
Wow. So it's like this self-contained little kingdom almost.
Or maybe a vertically integrated company, yeah, with a single all-powerful CEO.
And that CEO is the Paterfamilias.
Exactly. And legally, he wasn't just defined as the father. He was the oldest living male ancestor. That's key.
Meaning you could be a grown man, say 50 years old, maybe even a consul, high up in Roman politics.
Yep. But if your own father was still alive, you were legally still a dependent. In potestate, he was your paterfamilias. You answered to him legally.
That structure, that kind of centralized authority, feels really important for a society moving away from older ways of organizing.
Absolutely critical. The sources link this structure directly to the idea of settling down, owning land. It's a contrast to the older, maybe looser structures of the gens, the clans, which might have been more suited to a nomadic past.
How so?
Well, in the older gens idea, the sense of belonging, the union, didn't really end with death. There was this concept that, if nobody had ever died, all members would still be under the potestas of some distant common ancestor. It's more abstract.
Right. Whereas the paterfamilias is the living, breathing embodiment of that authority right here, right now. Makes the legal power very real, very immediate in the household.
It concentrates everything. The familia, tied at the land with the paterfamilias in charge, it centralizes legal responsibility. The state knows who to deal with. It's one guy, not a whole network of cousins and uncles with unclear standing. He's the governor of his domain.
Okay, and within that domain, how is this relationship maintained? It wasn't just legal, right? There's a moral dimension. You mentioned pietas.
Pietas, yeah, that's a huge Roman concept. We often translate it as duty or piety, but it's heavier than that in this context.
What did it mean between, say, a son and the paterfamilias?
It meant strict obedience, absolute respect. And what's really fascinating, the jurists themselves draw this comparison. They say the obedience owed within the familia is basically the same kind of religious duty Romans owed to the gods.
Wait, really? So disobeying your father is like blasphemy.
That's the implication. Think about it. Romans called their top gods Pater and Mater, Jupiter Pater. They saw the gods as the ultimate patriarchs, the ultimate heads of divine households.
So drawing that parallel makes the earthly paterfamilias' power sacred. untouchable.
It elevates it beyond just a legal arrangement. It
Yeah.
becomes moral law, a fundamental part of the cosmic order, almost.
Which provides a pretty powerful justification for a system where, well, individual autonomy doesn't seem to count for much.
Precisely. And the legal texts give us a really stark example of this lack of autonomy. It's quite shocking, actually.
What is it?
It concerns the action for insult, what the Romans called contumely. If you were a dependent child, son or daughter, still in potestate, and your own father seriously wronged or insulted you,
Yes.
you were legally barred, completely forbidden from bringing any kind of legal action against him for that insult. Doesn't matter how bad it was.
Hold on. So even if it was like public humiliation, really severe verbal abuse, something that would clearly be actionable between strangers.
Absolutely no recourse within the family if you were in postate. The law was absolute on this.
Why? What was the thinking there?
The jurists were reinforcing the idea that your legal identity, your personhood, was completely contained within the paterfamilias. You didn't exist as a separate legal actor in relation to him.
So you couldn't sue the very person who defined your legal existence.
Exactly. Allowing that suit would be like the law contradicting itself. It would undermine the entire basis of potestas. It's a kind of legal immunity built into the very structure of domestic power.
That really drives home the daily weight of this power. It's not just about extreme theoretical rights, is it? It's about the constant legal reality of being, almost invisible as an individual.
And that legal invisibility, it leads right into the next big question. Money. Property. What happens when someone in potestate actually earns something? A grown son running a business, maybe a particularly skilled slave generating income. Where does that wealth legally sit?
Yeah, good question. This brings us to the concept of peculium, right?
Exactly. Peculium. This is where the legal theory hits the economic pavement, so to speak. And it shows how the Romans managed this dependency in a very practical way.
So what was it, technically?
Peculium was property money, goods, maybe even other slaves that a son or a slave acquired. Could be through trade, maybe inheritance from their mother's side, or running some kind of business.
Okay, so they acquire it.
But, and this is the crucial bit, legally it was still owned by the paterfamilias. The son or slave might manage it, use it, even profit from it day to day.
But the title deed effectively stayed with the patriarch.
That's a good way to put it. Now, in practice, especially for sons, the father would often allow them considerable freedom to use their peculium. It was an incentive, right? Let the son run a workshop, manage a farm plot.
Okay, so the son's running, let's say, a shipping business using his peculium. What happens if it goes bust? If he racks up huge debts, can the creditors come after the paterfamilias for everything?
Now that's where the legal system gets clever. And we have details from jurists like Gaius on this. Generally, yes, the paterfamilias could be held liable for contracts made by his dependents in the course of business. But that liability was usually limited to the value of the peculium itself. The assets specifically tied to that son's or slave's activities.
Oh, I see. So the creditors couldn't usually go after the father's main family estate if the son's venture failed?
Not typically, no. The peculium acted like a sort of firewalled fund. It protected the core family wealth.
That's smart. Very pragmatic.
Extremely pragmatic. The jurists even developed specific legal actions for creditors. There was the actio instatoria that applied if the father had clearly set up the son or slave to run a specific business. It gave creditors a direct claim on the assets involved in that business.
Okay.
Then there was the actio tributoria. This was used more when the dependent was trading generally with his peculium, maybe without the father's direct mandate for that specific trade. In that case, the father had a duty to distribute the peculium fairly among all creditors.
Including himself if the son owed him money?
Yes, including himself. So he gets treated like any other creditor in that situation, further limiting his exposure.
So the system lets the father benefit from the dependent's work, encourages enterprise even.
While capping his own financial risk almost entirely to the funds he'd already notionally allocated to that dependent. It's a brilliant mechanism for control and limited liability long before modern corporate law.
The control seems relentless. What about something like military pay? Surely if a son served in the legions, risked his life for Rome, his earnings were his own.
You'd think so, wouldn't you? That was called the castrans peculium, military earnings. It did have special status eventually, granting more independence, but the underlying principle of paternal ownership died hard.
How so?
Gaius gives us this striking rule. Let's say a father, in his will, leaves a slave that was actually bought using the son's military earnings to someone else, a third party.
Okay.
If the son then dies before the father, that legacy in the father's will, it holds good. The third party gets the slave.
Even though the son earned the money.
Yes, because the law retrospectively says, well, the father technically owned those earnings, and therefore the slave brought with them all along. It shows just how deep this idea of the father's ultimate ownership ran. True independent ownership, true succession rights for the dependent were just not fully recognized while the father lived.
Wow, you literally couldn't earn your way out of that legal dependency.
Not easily, not completely. And this same logic, this reluctance to grant full independent status, it stretched beyond the immediate family too. It affected people who were technically free.
Like who?
Consider Junian Latins. These were former slaves who'd been freed, but maybe through a less formal process. They got certain rights, crucially, the right to do business, aeneas commercii. They could trade, own property acquired through trade.
Sounds pretty free.
But another big say, but they were legally incapable of making a will. They couldn't pass on their property as they chose.
So what happened when they died?
Their property, the bona latini, wasn't treated like a normal inheritance and hereditas. The law classified it. Guess what?
As peculium.
Exactly. It reverted entirely back to their former owner, the patron, or to the patron's heirs. It's the patria potestas model, echoing in the relationship between patron and freedman.
So the law just refused to see that property as truly independently earned, even after death.
It shows how dependency was the default legal framework. Full autonomy was the exception that had to be explicitly granted and recognized, and for many, like Junian Latins, it never fully was in terms of succession.
This whole structure of dependency, this legal shadow cast by potestas, it feels like it was fundamental to how Roman society actually functioned.
Oh, absolutely. It underpinned the whole economic and social order. Think about freedmen more generally, the mid-Oaci. For a long time after being freed, they were still kind of viewed as legally not quite fully free, de jure non-free, as the source puts it.
Meaning their former master, the patron, still had rights over them.
Significant rights. The patron could still demand financial contributions from his freedmen if he fell on hard times. And get this, the patron retained a right to discipline them, even call them to account criminally before him for lesser offenses, bypassing the public courts.
A patron could act as a judge over his own freedmen.
To some extent, yes. This incredibly tight bond, this original dependency, it did lessen over time, especially as freedmen got wealthier, more integrated, and started using the regular Roman courts themselves. But the starting point was deep subordination.
And this all ties back to?
It all ties back, ultimately, to Rome's reliance on slavery. Having this huge population of enslaved people, mostly forcibly imported foreigners, created the base of the pyramid. Their exploitation allowed even relatively poor, free Roman citizens to feel superior, to maintain a sense of independence, even while vast wealth accumulated at the top. Dependency, in various forms, was just woven into the fabric of society.
Okay, so the Paterfamilias wields this immense power throughout his life. But what happens when he dies? Does that power just evaporate?
Not exactly. It doesn't just vanish. It sort of transforms.
Yeah.
His death triggers changes, certainly. Everyone directly under his power, his sons, his unmarried daughters, his grandchildren whose own fathers had already died, they become sui juris.
Meaning legally independent, masters of their own affairs.
Legally independent, yes. But the law recognized that independent didn't necessarily mean capable, especially for minors. So the paterfamilias' authority continued in a way through the system of guardianship he could set up in his will.
He could appoint a tutor, a guardian.
Right. He had the authority to appoint a tutor for his descendants. This was standard practice for male descendants who were still in pubes below the age of puberty, usually around 12 for girls, 14 for boys in Roman law.
Okay, that makes sense, protecting minors. But what about female descendants?
This is where Roman law really diverges from our modern ideas. The sources are explicit. The father could appoint a tutor for his female descendants of whatever age they may be.
Whatever age. Even if they were adults.
Even if they were married.
Even if they were married and had children of their own, yes.
Why? What was the justification for that?
The ancient legal doctrine cited the supposed lightness of mind of women levitas animi. It was this ingrained belief that women, regardless of age or status, lacked the necessary judgment for managing serious affairs, particularly financial and legal ones.
That's quite something. Lifelong legal infantilization, essentially. Pretty much. So you could have a respected matron running a large household, influential in her own right, but legally, if her father had appointed a tutor for her in his will years ago, she might still need that tutor's formal approval for major contracts, or property transactions.
Did that actually happen in practice, or did wealthy women find ways around it?
The practical reality softened over time, especially by the classical period. Wealthy, experienced women often managed their affairs with considerable independence, using legal strategies or finding cooperative tutors. But the underlying legal principle, the tutela mulierum, the guardianship of women, remained on the books for a very long time. It showed the enduring power of that paternalistic structure.
And what about younger people whose fathers died? How did the system evolve beyond the father's direct appointment?
The law developed broader concepts of tutela and curatio. Tutela was primarily for those under puberty. Curatio was for young adults. The later rule established that basically everyone under 25, male or female, whose father had died, needed a curator.
What did the curator do?
Mostly oversaw property and financial matters. It was partly protective, shielding young adults from being cheated or making foolish decisions. But it still represented a form of institutionalized supervision, replacing the direct authority of the deceased paterfamilias. The state stepped in a way.
Okay, let's shift from property and legal capacity to something even more personal, marriage. How far did the father's control extend there, especially after his death?
This is another area where you see the incredible persistence of paternal authority. The father's will, his decisions were meant to echo down through time.
How so?
There's a specific ruling cited from late Roman law that's really revealing. It concerns a betrothal, an engagement pact, made by a girl's father while he was alive.
Okay.
The ruling stated that this betrothal pact remained legally binding on the daughter even after her father had died.
Wow. So a promise made by her dead father could still legally obligate her to marry someone, potentially against her own wishes or the advice of her current guardian.
Exactly that. The ruling specifically said that her guardian, the tutor or curator appointed after the father's death, did not have the right to break that engagement pact.
Even though the guardian normally stepped into the father's shoes for managing her affairs.
Yes. This decision carved out an exception. It prioritized the deceased father's original intention regarding his daughter's marriage above the current judgment of the guardian, and certainly above the young woman's own preference. It essentially locked in the father's control over her marital future from beyond the grave.
That's a profound level of enduring power. It brings us back to that idea of legal immunity we touched on earlier. Inside the family, the father's power was almost absolute. Did the state ever intervene if things got truly bad, if he became tyrannical?
The state was extremely reluctant to step inside the walls of the Roman household. The familia was considered a private, almost sacred sphere. Intervention was rare, and usually only considered in cases of really extreme aggravated abuse.
And even then, it depended on who was being abused, right?
Very much so. The law drew sharp lines based on status. We saw the example with freedmen earlier.
Right, the patron could discipline his freedmen.
Yes, a restricted right of punishment was allowed, seen as part of the ongoing patron-client relationship. The praetor, the magistrate in charge of the courts, would only step in for really serious stuff, what the sources call aggravated offenses.
Like, what counted as aggravated?
Things like excessive whipping, causing a grievous wound, or maybe trying to treat the freedman as if he were still a slave. Short of that, harsh words, maybe moderate physical discipline, the law wouldn't likely get involved. The bar for intervention was set very high.
Okay, that's for a freedman. What about an actual child, someone still fully in potestas?
For them, the bar was effectively insurmountable when it came to actions against the father for personal wrongs.
We talked about the action for insult, contumely.
Exactly. Now, if a child was not in the father's power, maybe an emancipated son, there was a slim theoretical possibility they might be granted that action if the father's actions were incredibly egregious, suggesting extreme cruelty.
But for a child still in power?
Never. The legal texts are adamant. The action for insult was absolutely never allowed for a child in potestate against their own paterfamilias. Full stop.
That legal immunity is the ultimate expression of his authority, isn't it?
It is. It shows the state essentially saying, this sphere is yours to govern. We grant you this power, and we will not interfere with your administration of your household, short of maybe the most extreme crimes like homicide. The structure of authority consistently trumped individual protection within that unit.
It's still hard for us looking back to really grasp how a society like Rome, which genuinely prided itself on law, on order, inticis, could create and maintain such a deeply hierarchical, almost oppressive domestic structure. It wasn't just random custom, was it? They had philosophical justifications.
Oh, absolutely. This wasn't just the way things were done. The Romans, especially the jurists and educated elite, thought deeply about the foundations of their legal system. To understand their justification, you have to look at how they categorize law itself. They had these three fundamental types of interests.
Okay, what were they?
First, the most specific, was exesis civil, civil law. This was the body of laws, statutes, customs, interpretations that a particular political community, the civitas, the city-state of Rome, established for itself, laws for Roman citizens.
Right, law specific to Rome.
Then they look outward. There was exius gentium, the law of nations, or maybe law of peoples. This was understood as the principles and rules that all peoples, all gentes, seem to observe naturally.
Like what sort of things?
Basic ideas about contracts, rules about property, warfare, treatment of envoys, and, importantly for our discussion, basic principles of social organization, like the existence of family structures and dependency. It reflected common human practices.
And was that different from the third type?
It often overlapped, especially in the writings of someone like Cicero with a third category, exis naturale, natural law. This was seen as the law derived from nature itself, from reason, the inherent rightness of things, what is lawful according to the fundamental order of the cosmos.
And the word equitas itself is interesting. It doesn't just mean law like a statute book.
No, it's much broader. It can mean justice, right, legal power, or even an individual's right or privilege or legal standing. It's a really comprehensive term.
So how did these categories help justify something like patria potestas?
Well, by framing it not just as a peculiar Roman custom, continuum civil, but by suggesting it had roots in the fanus gentium look, all societies have some form of family headship, some hierarchy. They can give it a sense of universality, and maybe even hint that it aligned with immius natural men, with the natural order of things.
The argument becomes, hierarchy is natural, therefore our extreme version of hierarchy is justified by nature.
That's essentially part of the justification, yes. It allows them to ground this immense power in something seemingly objective and universal, not just arbitrary tradition. And this Roman tendency to ground their structures in broad principles made them very receptive to certain kinds of philosophy.
Specifically Stoicism, right? Which seems ironic.
It does seem ironic, because we often associate Stoicism with inner freedom, rational self-control, virtue is the only good, things that seem quite individualistic.
So how did Rome, this powerhouse of social control and hierarchy, latch on to Stoicism?
They took the core Stoic idea of a rationally ordered universe governed by divine logos, or universal law, and they translated it into Roman terms. They understood this universal law not just as abstract reason, but as a kind of supreme intelligent rule, a supreme imperium.
Ah, imperium. There's that key Roman word again. Command, authority, the right to rule.
Exactly. They mapped the philosophical concept onto their existing political and legal framework. So, for the Roman mind, steeped in ideas of order, obedience, and the power of the magistrate, disobeying this universal rational law wasn't just a mistake.
It was like treason.
It was like moral high treason,
Yeah.
per duello, an offense against the very structure of reality, the cosmic order itself.
Okay, I see the connection now. If the universe itself is governed by a supreme imperium, a rational law.
Then maintaining order within the human sphere, mirroring that cosmic order, becomes the highest duty. And where does human order begin?
In the familia, the basic building block of the state.
Precisely. So challenging the paterfamilias, the legitimate authority within that foundational unit, isn't just disrespecting your father, it's potentially disrupting the rational order that holds the state, and by extension the cosmos, together.
That's a powerful justification.
It was incredibly effective. The sources note the Romans might not have been big on abstract metaphysical thinking, maybe not like the Greeks, but they absolutely got the Stoic idea of the universe as one big state, a civitas, with God and humans as citizens, all governed by this universal law of right reason.
Because it resonated with their own social and political structures.
Perfectly. If the universe is a state run by law, then human association, the Stoic ideal of connection between people, must also be understood through the lens of law enforced by legitimate authority.
So Stoicism, filtered through the Roman mindset, ends up providing philosophical cover for the existing hierarchies.
It provides a powerful intellectual framework. The authority of the paterfamilias, the patria potestas, isn't just some dusty tradition. It's presented as a necessary component for maintaining the rational order of the microcosm, the household, which in turn supports the macrocosm of the state and even the universe. Thinkers like Cicero could argue that stability depends on obedience within this hierarchy. The paterfamilias becomes an administrator of universal law within his own domain.
So a philosophy that for the Greeks, might have been about liberating the mind.
Gets adapted by the Romans to reinforce legal and social bondage, all in the name of rational order and the rule of law. Hashtag Shag Outro.
Right, let's try and pull the threads together here. What we've seen today is that the paterfamilias wasn't just, the head of the family in a loose sense. He was the absolute legal, economic, and social center of the familia.
His power, the patria potestas, was total. It was rooted deep in Roman tradition, yes, but it was also meticulously defined and upheld by Roman law for centuries.
And it permeated every aspect of life for those under him. From who technically owned the money a son earned serving in the army,
To whether a grown, married daughter still needed a guardian's stamp of approval for legal acts, based on a decision her father might have made decades earlier.
I think that legal codification is maybe the most crucial point. Roman law defined dependency, defined potestas so completely.
That the individual personhood of the dependent, the son, the daughter, the wife and manu, the slave, even the freedman to some extent, was just legally invisible to the state in many contexts. They were independent actors. They were extensions of the patriarch.
So while we might focus on the most extreme theoretical powers, like the ancient right of life and death over children, which certainly existed early on but became very rare.
The real story, the day-to-day reality for millions, was that constant, legally enforced expectation of absolute obedience. That was the norm. That was the weight of patria potestas.
And we saw how even sophisticated philosophical ideas, concepts like right reason or universal law from Stoicism,
Ideas that, in Greek hands, might have spurred thoughts of individual freedom or intellectual liberation.
were ingeniously adapted by the Romans, used to provide an intellectual justification for a system where individual autonomy was fundamentally subordinate to the authority of the oldest living male ancestor, all in the name of stability and order.
A fascinating and perhaps chilling example of how ideas can be repurposed.
Which leaves us, and you listening, with a final thought to maybe chew on. We think of Rome and its power, the legions, the Senate, the emperors, the vast state apparatus. But in a society that prized law and order above almost everything else, was the ultimate power actually held by the state? Or was it wielded day in and day out with near unquestionable legal authority by that single man, the paterfamilias, administering his own form of law within the walls of his home?
Where did the real power truly lie? That's the enduring question, isn't it?
Indeed it is. Until next time on The Deep Dive.